Hello, everyone, and welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd. Obviously, we're going to talk about Title 28, United States Code, Section 2254 and Section 2255, and why is that so relevant and important today? Scouring social media and the internet, I have not seen anybody talk about this. So this pertains to state and federal prisoners all across the United States of America. This is a huge day. Well, actually, not today, but I would say, what was it? Saturday? Huge day. I'm talking about the opinion from the United States Supreme Court in A.A.R.P, which does not stand for the Association of Advancement of Retired Persons. It's the actual initials of a foreign terrorist gang member versus Donald John Trump et al. So I've covered this, but in covering it, I found some oddities. And in oddities, I mean insanity. Okay? If you didn't get a chance to go watch those videos, I'm just going to break it down to you. All right? This is the definition of insanity. I went and put it in, define insanity, click. It's the first thing that popped up. Number one, a severe mental illness or derangement that is not used in psychiatric diagnosis. So obviously, all this Trump derangement syndrome going on and this Tesla and Elon Musk derangement syndrome, obviously we have some mental illness. We have some insanity going on. Number two, unsoundness of mind, sufficient to render a person unfit to maintain a contractual or other legal relationship, or sufficient to warrant commitment to a mental health facility. Now, let's break that down, okay? We have 9 justices on the United States Supreme Court. All of them took an oath of office. We all know what the oath of office says, that they are, sworn to uphold and defend the state and federal constitutions from all enemies, foreign and domestic, and not to render aid. Well, an oath of office is a contract. That's a contract with the people. So, if you're unfit to maintain a contractual or other legal relationship, you're insane. So 7 justices on the United States Supreme Court are obviously insane by definition. And I'm going to get into the whole mumbo jumbo about this. So let me move on to number 3. Number 3, incapacity to form the criminal intent necessary for legal responsibility, as when a mental disorder prevents a person from knowing the difference between right or wrong. All right. Now, let me explain to you what happened and why this also fits the 7 justices on the United States Supreme Court as, obviously, by definition, insane. Okay. This isn't even my opinion. I'm going to present the facts to you. So this is what transpired. These slick ass ACLU attorneys marched into court last Friday, which obviously is Good Friday. They came into court at the wee hours of the court's day and filed this application for motion for temporary restraining order. Basically an injunction to prevent deportation of, obviously, terrorists, gang members. That potentially might happen. Okay? They haven't even left yet. Actually, they're still here. So, the ACLU lawyers, okay? Let me break this down to you. This book right here, see this book? This is the Texas Rules of Court Federal. Okay. This is from 2010, and this is my book. But these are the federal rules of civil procedure. So you actually have to follow the rules to play the legal game. Well, you obviously have to notice the other party and give them time to reply. Well, the ACLU lawyers gave the court a mere, okay, now this is the attorneys telling the judge, hey, you got 43 minutes to adjudicate this application. If not, we're going to go file an appeal with the U.S. Court of Appeals for the Fifth Circuit in New Orleans. Well, being Good Friday, the end of the day, I'm sure some of the court staff had left, gone home early, go enjoy their Easter weekend. The court didn't rule on it in 133 minutes. So the ACL lawyers filed a notice of appeal with the Fifth Circuit U.S. Court of Appeals. So the Fifth Circuit in New Orleans, okay, this is on Friday, were aware that a notice of appeal had been filed in the A.A.R.P versus Trump. They knew it was there. But being a holiday weekend, and they did this shit on purpose, the court was like, we'll get with that Tuesday. Let's go enjoy Easter like the rest of the world. No, 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 no. What did the ACLU attorneys do? Well, they violated their state bar rules. They're disingenuous with the court, unethical behavior. So they just hey, Fifth Circuit, you're too slow. So we're just going to we're going to hit that powerful Mach 5 button on the steering wheel column and go, dunk, 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 dunk. And we're just going to jump right over the Fifth Circuit. U.S. Court of Appeals, who cares about them? We're going to go directly to the United States Supreme Court. Well, without the Fifth Circuit having adjudicated on the appeal for the application, which was never denied by the court, it was never granted. It's literally still there in limbo. The United States Supreme Court was without legal jurisdiction, folks. Okay? If you follow the rules, the case should have never left the Fifth Circuit U.S. Court of Appeals. Actually, it should stay in the U.S. District Court, and the notice of appeal should have been denied as unripe, okay? Because the ripeness hadn't established for them to file the notice of appeal because there was no adjudication on the actual application in the district court. So John Roberts, the Chief Justice of the United States Supreme Court, allowed this to fly. You acted without jurisdiction, without legal authority. And what happens when a judge or a justice acts without jurisdiction? Everything that judge does is void and moot. Period. End of fucking story. So everything that they've just done, that's void and moot. But who's going to hold them accountable? There we go. Okay. There's nobody to hold the United States Supreme Court accountable. They definitely won't hold themselves accountable because they are all, not all of them, but 7 of them are definitely insane by definition. They violated their contractual oath of office. They committed an illegal act. They acted outside the law. They're outlaws. Can I get a U.S. Marshal, please, to go arrest those 7 Supreme Court justices, take them into custody, and hold them for treason? Please? Hello? You hear my voice? Do you need to see my papers to prove that I'm a U.S. citizen or a U.S. national? Because if I remember correctly, the government works for we the people. and this is what I'm talking about, okay? And I'm talking about all my law enforcement buddies out there on the state, federal, local level. When are you going to grasp some fucking balls? When are you going to get some fucking integrity, some honor, some good faith that we can all look at and aspire, okay, and be proud that you're protecting us, you're serving us, you're doing what you're supposed to do instead of harassing us, hiding on street corners with your little radar gun around the corner, zapping people. You have to hide? No, you're here to protect and serve. Why do you have blacked out vehicles with ghost insignia on it? Why are you hiding? You shouldn't have to hide. You should be out front. You should be the brightest vehicle on the block. But they're not. So this is a commentary on our law enforcement because they refuse to act. They refuse to enforce the law. It's clear these people have acted outside the law. This is in the history of the United States of America, which we're 249 years, we're going on 250, never happened, ever. Which brings me to this video, because again, we have a historical act by the United States Supreme Court. United States Supreme Court just legislated from the bench. They just created an entirely new law. This book right here is called Federal Post-Conviction Remedies and Relief Handbook with Forms. And you see most of these are old because that's back when I was in prison. And to prove that, yep, I was there. And I don't think this book is stamped. No, but this tells you everything that you need to know about filing a Title 28 U.S.C. Section 2255, not to be confused with 2254. So we're going to go read these to you. I mean, I can go read the Fifth Circuit rules if y'all want. They have all kind of rules in here, how long the petition should be. Rule number 8, stay or injunction pending appeal. For text of this rule, see Federal Rules of Appellate Procedure. Okay, so that's what they're telling us to do. We're going to go over there and we're going to look at that. For rules of evidence, Federal Rules of Civil Procedure. And okay, I'm going to have to go read it because it's not the same rule number. My light sucked over here because I don't have any overhead light. Trials, judgment, provisions, final remedies, special proceedings. Judgment, new trial, entering judgment, declaratory judgment. No, stay of proceedings, enforcement of a judgment. 65. So what they wanted was a temporary injunction, temporary restraining order. Here we go. Rule 65, injunctions and restraining orders. Preliminary injunction notice. The court may issue a preliminary injunction on notice to the adverse party. Uh-oh. Uh-oh. Number 2, consolidating the hearing with the trial on the merits before or after beginning the hearing on a motion for a preliminary injunction. The court may advance the trial on the merits and consolidate with the hearing, but they didn't do that. Okay, temporary restraining order. Number 1, issuing without notice. The court may issue a temporary restraining order without written or oral notice to the adverse party or its attorney only if specific facts in the affidavit or verified complaint clearly show that immediate irreparable injury, loss, or damage will result to the movement before the adverse party can be heard in opposition, and the movement's attorney certifies in writing any efforts made to give notice and the reasons why it should not be required. Contents. Every temporary restraining order issued without notice must state the date and hour it was issued, describe the injury, and state why it is irreparable, state why the order was issued without notice, and be promptly filed in the clerk's office and entered into the record. The order expires at the time after entry not to exceed 14 days that the court sets, unless before that time the court, for good cause, extends it for a like period, or the adverse party consents to a longer extension. The reasons for an extension must be entered into the record. Expediting the preliminary injunction hearing. If the order is issued without notice, the motion for a preliminary injunction must be set for hearing at the earliest possible time, taking precedence over all other matters except hearings on older matters of the same character. At the hearing, the party who obtained the order must proceed with the motion. If the party does not, the court must dissolve the order. Motion to dissolve on 2 days' notice. Okay, y'all pay attention to this. On 2 days' notice to the party who obtained the order without notice, or on shorter notice set by the court, the adverse party may appear to move to dissolve or modify the order. The court must then hear and decide the motion as promptly as justice requires. Security. The court may issue a preliminary injunction or a temporary restraining order only if the movement gives security in an amount that the court considers proper to pay the costs and damages sustained by any party found to have been wrongfully enjoined or restrained. The United States, its officers, and its agencies are not required to give security. Do you think they really coughed up some security for this? No. Contents and scope of every injunction and restraining order. We can go into that. I haven't seen it, so I can't compare this to what they actually filed. Okay. Execution. 70, enforcing a judgment for a specific act. A party's failure to act, ordering another to act. If a judgment requires a party to convey land or deliver a deed or other document or to perform any other specific act and the party fails to comply within the time specified, the court may order the act to be done at the disobedient party's expense by another person appointed by the court. When done, the act has the same effect as if done by the party. Okay, and it goes into some more specific writs. So basically, those are the rules of court. All right. This big fat ass baby. This is the Georgetown Law Journal. 36th Annual Review of Criminal Procedure from 2007. It's got the TDCJ stamp on it right there. You can barely see it, but it's there. So this big fat ass book breaks everything down. All right. Under Title 28, United States Code, Section 2254, a person in custody pursuant to a state court judgment may challenge the conviction and sentence in federal court by applying for a writ of habeas corpus. Habeas corpus petitions filed by state prisoners are subject to the rules governing Section 2254 cases in the United States District Courts. Section 2254 applications must follow or closely approximate the format prescribed by the 2254 rules. Jurisdiction and venue. A prisoner may file a 2254 petition either in the district court or in the district in which he is incarcerated or in the district in which he was convicted and sentenced. To apply for a writ of habeas corpus under 2254, the applicant must be in custody, a term that the courts have liberally construed to include not only incarceration, but also other significant restraints on personal liberty, i.e., parole and probation. Once a petitioner's sentence for a particular conviction has expired, the prisoner is no longer in custody under that conviction, and the sentence can no longer be challenged in an application for writ of habeas corpus. However, a petitioner can challenge a current sentence that has been enhanced by a previous conviction. In addition, a petitioner serving consecutive sentences is consecutive. Okay, that means they're stacked, not concurrent, which means they run together. Consecutive sentences are considered in custody under any one of them for the purposes of filing a writ of habeas corpus. Thus, a petitioner serving consecutive sentences may challenge a sentence that has not yet begun, one that is currently running, and the other one that has expired until all sentences have been served. Cognizable issues. Federal courts may entertain an application for writ of habeas corpus only on the ground that the petitioner's confinement violates the Constitution, laws, or treaties of the United States. Relief for violation of federal law by the state will be granted only if the violation rises to a level of a fundamental defect which inherently results in a complete miscarriage of justice or is inconsistent with the rudimentary demands of fair procedure. Violations of state law are not cognizable in a 2254 proceeding unless such violations are of constitutional magnitude. Thus, the general improprieties occurring in the state proceedings are cognizable only if they created a fundamental unfairness that violated petitioner's 14th Amendment rights to due process. Common habeas corpus claims include Sixth Amendment claims of ineffective assistance of counsel, Fifth Amendment claims concerning statements obtained in violation of Miranda versus Arizona, prosecutorial misconduct, significant judicial error, and claims of insufficient evidence. A claim of actual innocence is not cognizable absent an independent constitutional violation in an underlying criminal proceeding that led to the prisoner's conviction. Claims that evidence obtained in violation of the Fourth Amendment was improperly admitted at trial and are not cognizable if such claims were fully and fairly litigated in state courts. Claims of ineffective assistance of counsel based on deficient representation in litigating a Fourth Amendment issue, however, are cognizable habeas corpus claims. Okay, and I can sit here and break all this down for you. All right. And they didn't file a 2254, they filed a TRO. But I wanted to read this to you under the 2254, what that looks like and what it pertains. So let's move on. Title 28 U.S.C. Section 2255, Relief for Federal Prisoners. Section 2255, motions distinguished from Section 2241 petitions under the All Writs Act. And that's what they went in on, the All Writs Act under 2241. Got the books, folks, and I've read them multiple times. To challenge a federal conviction or a sentence after all appellate review opportunities have been exhausted, a federal prison must normally file a motion under 2255 to vacate or set aside the conviction or to correct the sentence. In a very limited circumstances, prisoners other than aliens held at Guantanamo Bay may instead challenge their detentions by filing a habeas corpus petition under 28 U.S.C. section 2241. See, they're in a whole different category. They're not under 2254, not under 2255. But yet, in their ruling under the 2241 All Writs Act in A.A.R.P versus Trump, they opened the door for class action status for state and federal prisoners. So I'll get into that. Let me just explain this to you so you're on the same page. You have a complete lay person's understanding of what that looks like. Hello.
This is Anna from Vital Health Grants contacting you with an urgent update.
Awesome. They won't even take my calls anymore. Can I go through the prompts and then I talk to them and I tell them, hey, am I wasting your time like you're wasting mine? Click. All right. Where were we? Guantanamo Bay. However, the savings clause, and savings clause is in parentheses, or I'm sorry, in quotes. The savings clause of 2255 forbids courts from entertaining habeas petitions under 2241 unless a motion under 2255 is inadequate or ineffective. Circuits, the U.S. Circuit's Courts of Appeals, have read inadequate or ineffective very, very narrowly, and only prisoners claiming actual innocence have been allowed to invoke Section 2241. Let me repeat that. Only prisoners claiming actual innocence have been allowed to invoke 2241. I can't make this shit up. When you know the law, you study the law, and you know what the law, how it's supposed to operate, and then when you see it, okay, not functioning as the rules state, it jumps out at you like a pink elephant in the middle of Main Street. Can't miss it. And that's what I've done. So we can get into 2241 part of it. Let me is it even going to have it in here? This book is, you're in prison, this book is indispensable. It's one of the best books you can get. It's all 1983 stuff. Yeah, I don't see anything on 2241, but I know it's in here. It's in the back. Maybe in the other one. Fees and schedules. Judiciary procedure. Court. Oh. Let's see what this says, 2241 in it. Here we go. (2241) Power to grant writ. Verse 1. All right. Title 28 U.S.C. 2241, power to grant writ. Writs of habeas corpus may be granted by the Supreme Court, any justice thereof, the district courts, and any circuit court judge within their respective jurisdictions. The order of a circuit judge, that's a court of appeals judge, shall be entered in the records of the district court of the district wherein the restraint complained of is had. The Supreme Court, any justice thereof, any circuit judge may decline to entertain an application for writ of habeas corpus and may transfer the application for the hearing and determination to the district court having jurisdiction to entertain it. The writ of habeas corpus shall not extend to prisoners unless he is in custody under or by color of the authority of the United States, or is committed for trial before some court thereof, or is he in custody for an act done or admitted in pursuant to an act of Congress, or an order, process, judgment, or decree of a court or judge of the United States, which covers the illegal aliens. And I'm not going to. He, being a citizen of a foreign state and domiciled therein, is in custody for an act done or admitted under any alleged right title, and I just go on and on and on how insane this whole thing is. But this breaks it down. 28 or 2242 is the application, what it should look like. Show you all this stuff. And let the glare. There we go. The application. Okay. 2244, finality of determination. 2245, certificate of trial judge admissible in evidence. 2246, evidence depositions, affidavits. 2247, documentary evidence. 2248, return or answer, conclusiveness. 2249, certified copies of indictment, plea, judgment, duty of respondent. 2250, indigent prisoners entitled to documents without cost. 2251, stay of state court proceedings. 2252, notice. 2253, appeal in a habeas corpus proceeding or a proceeding under section 2255 before a district judge. So that's not a 2255, but it's definitely a 2241. And that's a 2254. 2255. That's capital for 2261, 2262. Tolling. 2266, limitation periods for determining applications. Those are only 2254s and 2055s. Under nothing under the 2241 All Writs Act. Man, golly, all this just brings back memories. So, basically, what we have is that's criminal. Let's see if I can get in here. Yeah, this one doesn't have an index. Rules of Civil Procedure 23. All right. Rules of Civil Procedure, Rule 23, class actions. Everybody book up. Focus. There you go. Class actions. Let me read this to you. Rule 23, class actions. Prerequisites. One or more members of a class may sue or be sued as a representative parties on behalf of all members only if, number one, the class is so numerous that joinder of all members is impracticable. Number two, there are questions of law or fact common to the class. Number three, the claims or defenses of the representative parties are typical of the claims or defenses of the class, and the representative parties will fairly and adequately protect the interests of the class. B, types of class actions. A class action may be maintained if Rule 23A is satisfied and if, number one, prosecuting separate actions by or against individual class members would create a risk of A, inconsistent or varying adjudications with respect to individual class members that would establish incompatible standards of conduct for the party opposing the class, or B, adjudications with respect to individual class members that, as a practical matter, would be dispositive of the interest of the other members not parties to the individual adjudications, or would substantially impair or impede their ability to protect their interests. Number two, the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. Or number three, the court finds that questions of law or fact common to class members predominate over any questions affecting only individual members, and that a class action is superior to other available methods for fairly and efficiently adjudicating the controversy. The matters pertinent to these findings include A, the class member's interest in individually controlling the prosecution or defense of separate actions. B, the extent and nature of any litigation concerning the controversy already begun by or against class members. C, the desirability or understanding of concentrating the litigation of the claims in the particular form. And D, the likely difficulties in maintaining a class action. So we're going to move on to C, certification order, notice to class members, judgment issues, classes, subclasses. Number one, certification order. Well, did we certify the putative class? Let's go look. Time to issue. At an early practical time after a person sues or is sued as a class representative, the court must determine by order whether to certify the action as a class action. That did not happen in the U.S. District Court. That did not happen in the U.S. Fifth Circuit Court of Appeals. And apparently, somehow, when it got to the United States Supreme Court, we're going to certify it as a class. But there's no certification order. Is there? No. B, defining the class. Appointing class counsel. An order that certifies a class action must define the class and the class claims, issues, or defenses, and must appoint class counsel under Rule 23G. C, altering or amending the order. An order that grants or denies class certification may be altered or amended before final judgment. Number two, notice. 4, B1, which would be over here for Rule 23, B1 or B2, classes. For any class certified under Rule 23B1 or B2, the court may direct appropriate notice to the class. These are things that have not happened. How are you going to serve a class that's not even in custody yet, and you don't even know where they are or who they are? Have they put out a public notice yet soliciting for class members? I'm just asking. B, for B3 classes, for any class certified under Rule 23B3, the court must direct the class members the best notice that is practicable under the circumstances, including individual notice to all members who can be identified through reasonable effort. The notice must clearly and concisely state in plain, easily understood language, which is English, the nature of the action, the definition of the class certified, the class claims, issues, or defenses that a class member may enter an appearance through an attorney if the member so desires, that the court will exclude from the class any member who requests exclusion, the time and manner for requesting exclusion, and the binding effect of a class judgment on members under Rule 23C3. Number 3, judgment. Whether or not favorable to the class, the judgment in a class action must: A, for any class certified under Rule 23B1 or B2, include and describe those whom the court finds to be the class members, and B, for any class certified under Rule 23B3, include or specify or describe those to whom the Rule 23CB. Hey, brother, how you doing, man? I'm doing great, man. I'm right in the middle of a live. Can I call you back? All right, bro. I got you. Bye. And that was the foreign national, born national, A6 grind time, formerly known as Anthony Lawson. If you want, go check him out over on YouTube. A6 grind time, foreign national, born national. Go check him out. So I'm going to call him back. Where was I at? Judgment. Notice. We went through there. We got to the judgment and particular issues. When appropriate, an action may be brought or maintained as a class action with respect to particular issues. Subclasses. When appropriate, a class may be divided into subclasses that are each treated as a class under this rule. D, conducting the action. In general, in conducting an action under this rule, the court may issue orders that: A, determine the course of proceedings or prescribe measures to prevent undue repetition or complication in presenting evidence or argument. B, require to protect class members and fairly conduct the action, giving appropriate notice to some or all class members of any step in the action, the proposed extent of the judgment, or the members' opportunity to signify whether they consider the representation fair and adequate, to intervene and present claims or defenses, or to otherwise come into the action. C, impose conditions on the representative parties or on interveners. D, require that the pleadings be amended to eliminate allegations about representation of absent persons and that the action proceed accordingly or deal with similar procedural matters. Number 2, combining and amending orders. An order under Rule 23D1 may be altered or amended from time to time and may be combined with an order under Rule 16. Okay, these are the rules. You got to play by the rules. E, settlement, voluntary dismissal, or compromise. The claims, issues, or defenses of a certified class may be settled, voluntarily dismissed, or comprised only with the court's approval. The following procedures may apply to a proposed settlement, voluntary dismissal, or compromise. The court must direct notice in a reasonable manner to all class members who would be bound by the proposal. If the proposal would bind class members, the court may approve it only after a hearing and on finding that it is fair, reasonable, and adequate. The parties seek approval must file a statement identifying an agreement made in connection with the proposal. If the class action was previously certified under Rule 23b3, the court may refuse to approve a settlement unless it affords a new opportunity to request exclusion to individual class members who had an earlier opportunity to request exclusion but did not do so. Any class member may object to the proposal if it requires court approval under this subdivision E, and the objection may be withdrawn only with the court's approval. So basically, what the United States Supreme Court is open the door that any terrorist, gang member, illegal alien that's in custody at the Blue Bonnet facility in Conroe, and there's one in Louisiana, wherever they're at, okay, that they're part of a class and they can just gum this whole thing up, and this can take freaking forever. Why? Because of the insanity of 7 justices of the United States Supreme Court, which just set an unprecedented precedent, which basically opened up Pandora's box. So to break this down for you, and this goes into appointing, Court of Appeals. Almost missed it. F. A court of appeals may permit an appeal from an order granting or denying class action certification under this rule if a petition for permission to appeal is filed with the circuit clerk within 14 days after the order is entered. An appeal does not stay proceedings in the district court unless the district judge or the court of appeals so orders. You see how all this just like they just ran right over all this and just like, oh, we don't care. We need to get to those people up there who can, for the ultimate forebearers of bad news, the insanity. And this goes in derivative actions, prerequisites, Rule 23.1, derivative actions, prerequisites. A, this rule applies when one or more shareholders or members of a corporation, an unincorporated association, bring a derivative action to enforce a right. Amber alert. But that doesn't seem to apply here. Unincorporated associations, intervention of right. On timely motion, the court must permit anyone to intervene who is given an unconditional right to intervene by a federal statute or claims an interest relating to the property or transaction that is subject of the action and is so situated that disposing of the action may, as a practical manner, impair or impede the movement's ability to protect its interest unless existing parties adequately represent that interest. Permissive intervention in general. On timely motion, the court may permit anyone to intervene who, A, is given a conditional right to intervene by a federal statute or has a claim or defense that shares with the main action a common question of law or fact. Number 2, by a government officer or agency. On timely motion, the court may permit a federal or state governmental officer or agency to intervene if a party's claim or defense is based on A, a statute or executive order administrative by the officer or agency, or B, any regulation, order, requirement, or agreement issued or made under the statute or executive order. I'm pretty sure that Trump signed an executive order, did he not? Has he not said that all these illegal immigrants got to go? All these gang members got to go? And where's our government? They've abandoned us. Thank you, Pam Bondi. Thank you, Christy Noem. Thank you, Kash Patel. Did I miss anybody? Number 3, delay or prejudice. In exercising its discretion, the court must consider whether the intervention will unduly delay or prejudice the adjudication of the original party's rights. C, notice and pleading required. A motion, to intervene must be served on the parties as provided In Rule 5, whenever you file something, you have to serve the other party and you have to give the other party time to rebut whatever you file. That has not happened in this instance. As soon as that application was filed in the United States Supreme Court, the clerk of the United States Supreme Court should have denied without written order. No jurisdiction. As I said in my video yesterday, do you see some legal hanky-panky going on? So that basically breaks down the class action. Let's see if this is it. Okay. This is Samuel Alito's dissent. So we're going to read it. It's only a paragraph. You can cite this case 604 U.S. Page number is yet to be assigned. Associate Justice Samuel Alito dissenting, in which Justice Clarence Thomas joins. A.A.R.P. et al. Et al. Means that there are other parties in the plaintiff position. A.A.R.P. does not stand for the Advancement or Association of the Advancement of Retired People. That's the initials of a gang member, illegal alien. It has now been changed to another set of initials. Anyway, Donald John Trump, President of the United States et al., which means Trump and Company. Justice Alito, with whom Justice Thomas joins, dissenting shortly after midnight yesterday, and he wrote this on Saturday the 19th, correct? Yep, Saturday the 19th. Shortly after midnight yesterday, Friday, Good Friday, April 18th, 2025, the United States Supreme Court hastily and prematurely granted unprecedented emergency relief proceeding under the All Writs Act, Title 28 U.S.C. Section 1651. The court ordered, quote, the government not to remove a putative class of detainees. Okay? We can look up this term here in a minute. Until this court issues a superseding order, although the order does not define the putative class, it appears that the court means all members of the class that the habeas petitioner sought to have certified, namely all non-citizens in the custody of the Northern District of Texas who were, are, or will be subject to the March 2025 presidential proclamation entitled Invocation of the Aliens Enemy Act regarding the invasion of the United States by Tren de Aragua and or its implementation. Motion for class certification in this, boom, right there. And although the court does not specify what it means by the government, it appears that the term is intended to embrace all the named defendants, including the president. Compare Federal Rules of Civil Procedure 65D2. So would y'all like to go look that up real quick? Let's see what 65D2 is. Rule 65D. Contents and scope of every injunction and restraining order. That was 2. D2. Persons bound. The order binds only the following who receive actual notice of it by its personal service or otherwise: the parties officers, agents, servants, employees, and attorneys, and And that's it. That's D2 and C. Other persons who are active, who are in active concert or participation with anyone described in Rule 65D2A or B. That's compare. As we have an asterisk right here, it appears that the applicants have recently moved to amend their class petition for habeas corpus and their motions for class certification. See motions in blah, 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 blah. So it is not clear if the applicants will continue to defend the specific definition or will argue for a new one. The court did all this even though, okay, this is what he's saying. This is the insanity defined. Bullet point number 1. It is not clear that the court had jurisdiction. Speaking of the United States Supreme Court, the All Writs Act does not provide an independent grant of jurisdiction. See 28 U.S.C. Section 1651A, permitting writs necessary or appropriate in aid of a court's jurisdiction. The express terms of the All Writs Act confine the power of a court issuing process in aid of its existing statutory jurisdiction. The Act does not enlarge that jurisdiction. Therefore, this court had jurisdiction only if the Court of Appeals had jurisdiction of the applicant's appeal. See Section 1254, granting this court's jurisdiction to review the cases in the Courts of Appeals, and the Court of Appeals had jurisdiction only if the supposed order that the applicants appealed amounted to the denial of a preliminary injunction. See Section 1292A1. But here, the order that the applicants appealed was what they viewed as a district court's constructive denial of their request for a temporary restraining order, a TRO. That is, the district court did not actually deny their most recent request for a TRO, but they inferred that it was constructively denied, and they, the ACLU attorneys, inferred that it was constructively denied because the district court failed to rule on that request before the expiration of a truncated counsel-imposed deadline. Okay, not a court deadline, not a deadline set by the federal rules of a civil procedure or the federal rules of appellate procedure. The denial of a true TRO is not appealable. And here, it is not clear that the applicant's TRO request was actually denied. Indeed, in an order issued last night on Friday, April 18th, by the U.S. Fifth Circuit Court of Appeals, the Fifth Circuit held that it lacked jurisdiction for this reason. So if the Fifth Circuit Court of Appeals did not have any jurisdiction, the United States Supreme Court, God damn sure did not have any jurisdiction. Bullet point number 2. It is questionable whether the applicants complied with the general obligations to seek emergency injunctive relief in the district court before asking for such relief from an appellate court. When the applicants request such relief in the district court, they insisted on a ruling within 45 minutes on Good Friday afternoon, and when the district court did not act within 133 minutes, the ACLU attorneys filed their notice of appeal in the U.S. Fifth Circuit Court of Appeals, in which the district court held deprived of its jurisdiction. It is doubtful that this aborted effort satisfied rules of appellate procedure 8A1C. Bullet point number 3. When this court rushed to enter its order, the Court of Appeals was considering the issue of emergency relief, and we were informed that a decision would be forthcoming. This court, however, refused to wait, but under its court's Rule 23.3, except in the most extraordinary circumstances, an application for a stay will not be entertained unless the relief requested was first sought in the appropriate court or courts below or from a judge or judges thereof. Bullet point number 4. The only papers before this court were those submitted by the applicants, the ACLU attorneys. The court had not ordered or received a response by the government regarding either the applicant's factual allegations or any of the legal issues presented by the application. And the court did not have the benefit of a government response filed in any of the lower courts either. When the applicants first raised their allegations in the district court, that court provided the government with 24 hours to respond and was poised to rule expeditiously. But the district court dissolved the government's obligation to respond after counsel for applicants, ACLU attorneys, filed their hasty appeal, which, in the district court's view, deprived it of its jurisdiction to rule. Bullet point number 5. The papers before us, while alleging that the applicants were in imminent danger of removal, provided little concrete support for that allegation. Members of this court have repeatedly insisted that an All Writs Act injunction pending appeal may only be granted when, among other things, the legal rights at issue are indisputably clear and, even then, sparingly and only in the most critical and extingent circumstances. I'm not going to read these citings. Bullet point number 6. Although this court did not hear directly from the government regarding any planned deportations under the Aliens Enemy Act in this matter, and an attorney representing the government in a different matter, JGG versus Trump, informed the district court in that case during a hearing yesterday, which would be Friday the 18th, that no such deportations were planned to occur either yesterday, April 18th, or today, April 19th. Bullet point number 6. Although the court provided class-wide relief, the district court never certified a class, and this court has never held that class relief may be sought in a habeas proceeding. In sum, literally, in the middle of the night, the court issued unprecedented and legally questionable relief without giving the lower courts a chance to rule, without hearing from the opposing party, within 8 hours of receiving the application with dubious factual support for its order, and without providing any explanation for its order. I refused to join the court's order because we had no good reason to think that, under the circumstances, issuing an order at midnight was necessary or appropriate. Both the executive and judiciary have an obligation to follow the law. The executive must proceed under the terms of our order in Trump versus JGG, and this court should follow established procedures. There you go. So it's either up to the Department of Justice to go after these 7 insane justices by definition, the U.S. Marshals, or it's time for Clarence Thomas and Samuel Alito to throw their co-justices under the bus and out them and refuse to participate in this insanity. This is what we're lacking in this country: truth, transparency, and accountability. And until we start seeing that, all facets of American way of life are in jeopardy. Obviously, our education system's in jeopardy. The justice system is obviously broken. We know our law enforcement have a problem with their training, their education, what their real goals are, because their real goals are to reach in your pocket and take as much money as they can out of your pocket, or to bond you as a slave for the rest of your life. When we talk about a reset, Nassar, Jassar, Great Jubilee, it has to work across the board. We have to change almost every aspect of how we live life. No one person can know all the laws. Here, this is just criminal law on the federal level. You think you can learn all that? Even I don't even know all this book, and I've read this book probably a dozen times. Yes, a dozen times. And look at that print. Actually, that's my either second or third Georgetown Law Journal. So let's go back and let's look what is insanity. Insanity is a severe mental illness or derangement not used in psychiatric diagnostics. So that means this is not a clinical diagnosis. Number two, unsoundness of mind sufficient to render a person unfit to maintain a contractual or other legal relationship. So obviously, they're going way out of bounds with their judicial responsibilities because they have an oath of office to uphold. And they're violating that oath of office. So obviously, they're unfit to maintain a contractual or other legal relationship, or sufficient to warrant commitment to a mental health facility. And when you start labeling illegal immigrants who clearly violated the law to be here, have been designated and labeled a foreign terrorist organization, something wrong with that picture. The incapacity to form the criminal intent necessary for legal responsibility when a mental disorder prevents a person from knowing the difference between right and wrong. So, would you say following the rules is right, not following the rules is wrong? Because that's what we have here. And I know for most of my audience, man, this is going right over your head, doesn't pertain to you. You're not in custody formally. But for all my friends, my enemies, all those currently incarcerated in every state, U.S. territory, and all those in the BOP and on BOP parole, you now have the ability to apply and get, because this is the law of the land now. So every state petitioner, doesn't matter whether you're in Texas, Louisiana, Oklahoma, Alaska, every state petitioner who files a writ of habeas corpus for state custody relief, that's a class. That's a class. You have to serve them like a class. You have to treat them like a class. You have to notify every single one of them. You have to give them, you're going to have a notice that they want to be excluded from the class. You have to appoint the class counsel. Do you see the constitutional magnitude of your judicial irresponsibility acting as an outlaw? I'm calling treason, in my opinion. Those 7 justices need to be taken into custody immediately. They need to be sent to Guantanamo Bay, incarcerated as terrorists, in my opinion. And until we see that type of action, I don't care who the president is. I don't care what the president does. If that is broken, remains broken, and is not fixed and remedied before the eyes of the people, nothing in this country is going to change. It's going to stay the same. The justice system is going to remain corrupt, fraudulent, activist judges, all about the money and the bond and the Chris. court registry. That's the bank. As far as I know, I'm the only person in the world who has gone to the Depository Trust Clearing Corporation, GMEIutility.org, which is now defunct. But when it was operational, I put in 3 separate governmental issued ID numbers. My certificate of live birth issued by the state of Texas, the file number, my social security number issued by the Social Security Administration, and my last prison ID number issued by the state of Texas. I put those 3 numbers into the GMIutility.org database. I pulled up the same identical accounts for all 3 government issued ID numbers, which tells me there's something in the background. They're all connected. And they're hypothecating that bond. So there's a there, folks. And I proved it over and over. And as long as this corruption, this fraud, this outlawness that these judges just wantonly do without any repercussions or circumstances, because there's nobody to hold them accountable, and the people that should be holding them accountable are derelict in their duty. They all want to protect each other, and they don't even know why they're protecting each other. They're just doing it because, oh, we're governmental employees and we should look out for each other. No, you should take those governmental employees who are fucking people over because they're fucking your relatives over. They're fucking your friends over. You just don't see it or hear about it. And you're just letting that shit slide. And I've had somebody on my show who was a whistleblower for a county. Anita. I had to pull the videos off YouTube. Why? Because they didn't like her talking about it. They had people sitting outside of her house following her. She's like, Floyd, please take those down. And I did. But this is what they do. They gang tackle you, gang stalk you, trying to shut you down. Meanwhile, okay, y'all are over here following these idiots like David Lester Straight and Anna Von Reitz, going nowhere, wasting your time, money, and energy with this National Assembly bullshit that's going nowhere. Stop with the insanity. You want to make a difference, start locally. 2026, go run for office or go find somebody that has a like mind like you that wants to change our judicial system, our law enforcement system. You want to change your community for the better. You don't want law enforcement out here preying on the citizens. You want them out here protecting the citizens, not preying upon them, not locking them up. They actually have a disease like alcoholism. What do? You lock them up. And in here in Texas, they lock them up and that you don't get treatment. You don't go through a chemical dependency treatment. You don't go through any type of behavioral treatment. Only once you're granted parole by the parole board, you're assigned to go to a program or not. So if you're like me, I sat in prison. I sat in prison for 13 fucking years without any treatment, any behavioral programs. Why? Because you can only get those when you are granted parole by the parole board. So for 13 years, I'm in limbo. I had to file a civil RICO against the Board of Pardons and Paroles for chemical dependency treatment. And I withdrew it because they were beating me up in all these other civil RICOs. They were just flat not going to let me win. It didn't matter if I had the defendant on the stand admitting they violated my federal constitutional rights. They violated Texas prison policy and procedure. Case dismissed. What? Yeah. I even filed a writ of habeas corpus for emergency protective custody for chemical dependency treatment under the Texas Health Safety Code. That's when they went and changed the health and safety code behind my filing. Why? Because about 70,000 plus convicted felons in the custody of the Texas prison system had an admitted chemical dependency treatment upon their entrance to Texas prisons, which means that those 70,000 out of 100,000 could file that same legal vehicle, the writ habeas corpus for emergency protective custody under health and safety code, and get bench warranted back to their county for treatment because the state wouldn't provide it. Well, that would put an undue burden on every county in the state. Imagine Dallas, Bexar, Travis, Harris, El Paso, because those are your big counties that send the majority of the people to prison. Imagine having 20,000 people coming back out to your county, and now you got to give them treatment, and you don't have the funds to do that. So they changed the law. And then the court, instead of addressing the law in effect at the time that I filed it, they went with the new law. And they lied. Imagine that. So this is the issue we're going through. That's why I tell people, you got to play by their rules. And even when you're in there playing by their rules, they don't like to play by their own rules. That's why I wanted to have my guy on Monday talk about that repossession. He's got a court hearing at the end of June. He texted me earlier, give me an update. Yeah, I got that summons. Oh, here we go. It's put back on the docket, conference call at the end of June. So that will be his next proceeding. Maybe we can get him in before. I don't know. Like I said, he's under NDA, so that's all up to him how he wants to handle that. But this is the idiocy that's happening. Okay. Because now anybody that's in state and federal custody, if you're not incarcerated and you're out on parole and probation, still classified in custody under the law of the land, United States Supreme Court case, you're class. So all you have to do is file a motion for class certification. That's what you guys need to do. Y'all need to get you a standard template form, and everybody who's filing a 2254 and a 2255, y'all need to gang tackle. Y'all need to flood these courts for class certification. Y'all need to fuck this shit up. Okay? So all my writ writers, all my jailhouse lawyers across the country, this video is made specifically for you. So I know all of you in there who do follow me, and y'all do have cell phones and tablets and all that stuff. Y'all spread this video, man. Show everybody. Because this is what's going on. Insanity. These people are certifiably insane. Absolutely. So for those of you who have not been paying attention, in exactly 1 hour and 39 minutes, the bridge project will be in effect for 24 hours. It is a flash sale. Over 50% off select items. It begins at 5 p.m. Central Standard Time today. In just a little over an hour. It runs until tomorrow, 5 p.m. So if you've been looking for a book, a class, a combination, there you go. They're all available in the store. I will fire that up as soon as I get done with this video. If you've been waiting on scoring a book, now's your chance. All right, let me get over here to the comments. I have 10 of them. Hey, Matt, how you doing? Night Owl. The female Supreme Court justice who couldn't define what a woman is should never be on the Supreme Court. I agree. But again, we have a Congress full of greedy, corrupt, fraudulent representatives and senators that don't give a rat's ass about you, your family, your community, their constituents, their jurisdiction. They only care about themselves. Now, I'm not saying everybody in government's like that, but the majority, yes, you've been sold out. And I agree. If you cannot define what a man and a woman are, you're insane. You need to be locked up. And that's what we have to start doing. We have to start putting these people in a 72-hour psychiatric evaluation. And unless you see these people freaking out, call 911, say, I got one here that's crazy. They're acting abnormal, irrationally. I think they are mentally ill. And get them locked up. Believe me, when they get on a 72-hour hold and they start fed some of that antipsychotic medication, they're going to think twice about coming out here and acting a fool in society. Buffy, how you doing? All right, I'll give you a call after the show. I got to call A6 back. I'm breaking it down, folks. I break this shit down like nobody else breaks it down. And, why I don't have 1 million followers, I have no idea. But it is what it is, and I don't really care. And I'm going to continue to do what I do day after day after day after day, and nobody's going to stop me. If you want to stop me, you'll have to come over here and beat my ass up to shut me up. That's what I say. How you doing, Trash Dog? Welcome to the show. Baby Crab Cakes, how you doing? They reported this morning that a total of 6 guys were deported. 6. That is it. And Arizona is suing, stating that deportation is constitutional. Major pushback from Hobbs here in Arizona. Arizona is one of the most corrupt states. According to John Harris Taylor, this book, pop my bridge project out. This book right here, Report to the Governor. Racketeering, bribery, corruption, election fraud, how the discovery of mass corruption in the state of Arizona led to the abduction of McKinley Harris Thaler. If you have not read this book or even gone to the website, reporttothegovernor.com, I encourage you. Then you can find all about Arizona. And according to John, if you pulled out all of the illicit currency or money out of the state of Arizona, the Arizona economy would collapse. He said that's how corrupt Arizona is. And that goes all the way to the Arizona Supreme Court, judges and justices on all the courts, the politicians, law enforcement, prison guards, jailers. They're all corrupt. They're all paid off by the cartel, allegedly, in my opinion. I never trusted SCOTUS would ever rule in favor of the Brunson case, too corrupt. And let me break that down for you, Troy. Okay, and you have to look at it with logic and reason, because who were the parties named in the Brunson suit? Well, obviously it was Joe Biden, Kamala Harris, and then you had 386 members of Congress out of 535. So literally, if the United States Supreme Court would have acted on the Brunson case lawfully and legally, like they should have, it would have decapitated 2 of the 3 pillars of the United States of America institution, the executive branch, taking out the president and the vice president, and would also take out the legislative branch, Congress. We're the world's greatest power. That would never happen with logic and reason. Okay, because they would be cutting off, they would be surrendering their own power by throwing their own constituent or their own other legislators under the bus. So that's why, through logic and reason, I've always said they're never going to adjudicate that. Okay, never. It's not going to happen. It's DOA. And then if you went back and actually read the legal vehicles that the Brunson brothers were submitting at the very beginning, were, you know, I could get an elementary student probably to present something with the same level of legal acumen. When I read it, I was like, man, these people need help. So I called up Raylan Brunson and actually spoke to Raylan Brunson. And then I said, hey, man, you need some help. It looks like you don't have any access to Westlaw or Westlaw Online or LexisNexis. And no, we don't. Oh, well, hang on. Let me call somebody. And I called Brian Robertson, Pastor of the Way, who has a Westlaw account. Got him on the phone, and both of us talked to Raylan and said, hey, man, we'd love to help you out. We're here to support you because we want you to win. So this is our offer. When you draft another legal vehicle, just email it to me. I'll send it to Pastor. We'll go over it, make our edits, add anything that we need to it, and we'll send it back to you. If you use what we do, great. If you don't, that's great too. We don't care, but we would like to make our own contribution for the betterment of society. Never heard back. And I repeatedly called and left messages and emailed and did everything I could to get in contact with the Brunson brothers. And to this day, I've never heard a reply back from the Brunson brothers. And that's why I've always said, Brunson brothers case, DOA. But people don't want to listen to me. With my own track record as superlative as it is. How you doing, Savvy? Welcome to the show. I totally agree with you. Now, I've been saying that for quite a while. Yeah, I don't really know. Too many 10-second toms. TikTok brain can hardly watch a full movie, let alone a podcast. Yeah, is what it is. And I'm going to roll because I want to get this and broke down. How do these people pop up on the scene and just become famous, infamous, or just garner, tens of thousands of subscribers and followers like that? How does that even work? I've been doing this shit for 3 years on YouTube and all of the social media, and I have 16,000 viewers or subscribers on YouTube. And obviously I know I'm being shadow banned, but the point being is I've put out things here on my show that have never, ever been put out anywhere. Nobody's emulated what I've done. The late Senator Ted Kennedy, his assassination attempt at Chappaquiddick, that's nowhere in the public specter. That was broken by Noel Benoist on my show. Nothing. Crickets. So I've made some, I've done some things on here. Actually, one of the videos that I was thinking about this last night, one of the videos that I produced on here is actually a prerequisite at a college. I want to say New Mexico or Colorado. Seems like Colorado. It's mandatory in their class. One of the videos that I did. I've done some very spectacular things. So when I see these people pop up, and they just get this huge following, it disturbs me because, like, how did they get that? What are they doing? And especially when, and I'll use Chris Hauser. He's such an easy example. I mean, this dude busted on the scene, didn't even know what the fuck he was talking about, lined everybody up as guinea pigs. Everybody went out there guinea pigged for him. And he just blew up overnight and gets like 100,000 people following him, subscribing. And all I'm doing is listening to him, watching him, and I'm catching him in lie after lie after lie after lie after lie. I'm like, what the fuck? So I'm trying to tell everybody, this guy's lying to y'all. This is all bullshit, but nobody wants to listen. It's just like David Lester Straight. When I said 16 months ago, I did a video when he came out with his whole masterminds program with the Freedom bot, whatever that is, and those two knuckleheads. And he charged out this exorbitant, like $2,000 for the year. And within 12 months, you would have access to your minor trust. So David gets cancer. He's going through therapy. Well, everybody's subscription had to renew in January, and everybody got dinged for another $2,000. And yet not one individual in David's mastermind thing has access to their trust. And now David allegedly has passed away. There's no obituary. There's no death certificate. He died in Arkansas. Why somebody that would have cancer would be in Arkansas, when if you have cancer and you're going to go the traditional Western process, you would be at MD Anderson in the Med Center in Houston, Texas, the #1 oncology hospital in the fucking world, where kings, princes, prime ministers, presidents, vice presidents, politicians, celebrities, everybody goes to MD Anderson. Eddie Van Halen, MD Anderson. They all go to MD Anderson. But yet, David Lester Straight's in Arkansas and dies in Arkansas. He's from Oregon. His family's in Oregon. Yet, they're going to have a ceremony in Oklahoma City. Well, his wife, Bonnie, is from Dallas-Fort Worth. They were living outside of that on a ranch, and how they ended up in Arkansas, and then we're going to do a ceremony in Oklahoma City. And are you seeing what I'm seeing? Are you hearing the words coming out of my mouth? It's a shit show. If you're still involved with Anna Von Reitz, David Lester Straight, or any one of the assemblies, you're fucked. Stop. You're not going to go anywhere. Hello. Hello. Can you speak? Yeah, this is Floyd. Yeah. And that's how it runs. And that is as it should be. Fucking people. I swear. So I don't know if they're compromised or not. They may be. You're welcome. How you doing, Hargis at 606? You're welcome. You can purchase views, fake it till you make it, in my opinion. Yeah, but who can start a social media platform? Because you can get away with some of this free, but if you're, you do this every day, all these subscriptions cost money, and it adds up after a while. Especially, you got your website fees. You got somebody building your website for you. You got to pay for that. You have to pay for StreamYard. It just goes on and on and on. What I purchase views, no. But, there's people out there like Phil G who have fake numbers. I've got 500,000 people watching me right now. Bro, you're not the Super Bowl. No. Is what it is. But basically what this video is all about is that the United States Supreme Court has clearly acted outside any rational responsibility as a juror for American jurisprudence. Obviously, they've acted outside the law, so they are outlaws. They definitely don't know the difference between right or wrong. They've overstepped their judicial authority. They violated their oath of office, all in support of an illegal alien, a gang member, and certified terrorists. That's what your Supreme Court has done. So all my viewers, state and federal prison, you can now file for class certification as a habeas petitioner on the state and or federal level. So y'all go out there, y'all create some mayhem, because I know you're all qualified to do it. I know you've all got a pen, some paper, carbon paper, and plenty of time on your hands. So go set some precedent. Go be somebody. Go make a name for yourself like I had to do. Like when I was a writ writer and I could go, you see this case? I'm published, bro. Is anybody else in this law library published? Nope. Again, take it or leave it. These are my terms and conditions. If you don't want them, that's fine. There's 20 guys in here who'll blow smoke up your ass, tell you everything that you want to hear, and take every penny your mom and dad are going to send you from commissary. Absolutely. So that's the deal. Oh, you're welcome. I'm going to do some more stuff today. I have a lot of stuff to do. Got a big weekend coming up. I have tentatively made plans for Memorial Weekend, and I will be up in the Austin Round Rock area for Memorial Weekend. I'm going to go ahead and start establishing plans for that. I'm going to go out there and hang out with one of my longtime viewers, subscribers, and friends. A person way back when Chris Hauser broke on the scene, I told her flat out, this whole thing he's doing is bullshit. Watch. Nobody's going to get a car. Nobody's going to get a house. Watch. And I was right. So there you go. Thank you for watching. Don't forget the bridge project. It will light up here in about an hour and 19 minutes. And if you don't know what I'm talking about with the bridge project, I'll explain it to you. Ann LaFleur, my co-author and associate and friend, she lives on an island in the French Polynesian chain by Tahiti. And apparently about 2 weeks ago now, they had a flash flood, and the bridge that adjoins her property with the land so she can get to the market washed out. So we're doing a 24-hour fundraiser to get funds to send her to replace the bridge. Fortunately, I had the funds outright to send her immediately so that they can get started on it. So basically what we're doing is replacing those funds and doing a fundraiser for 24 hours. So if you wanted Ann's books, they're basically the ebooks 2 for 1. So if you were thinking about getting the On Trust book and, you know, you're waiting around, about now you can get the On Trust and specialty ebooks for the same price as one book. Classes that are available. If there's something that I have available that is not in the package that is amenable to you or your liking, hit me up. fearlessfloydshow@yahoo.com. fearlessfloydshow.com is my website. Just scroll down the very bottom of the homepage of my website. You'll get my cell phone number. You can call me right here. As you see, I answer the phone 9 to 9 Central Standard Time. If you call me beyond those hours, I do not see it. I do not hear it, and I ignore it. So if you've been waiting and holding out, now's your chance. The next sale I will do, more likely than not, will be Black Friday, Thanksgiving. So until that time, I did not get the specialty books soft cover book available simply because I'm waiting on the printer to send me their information, and I don't have the physical books in my hand. Anything can happen between now and then, so I just made the choice not to offer them until because I don't know, you know, how many people are going to order. If I get overwhelmed and got, you know, 30 orders and I don't have any books, I don't like that hanging over my head. I learned a lesson when I worked at home entertainment selling high-end luxury electronics. Sell what you have and not what you don't. Because I sold some stuff that we didn't have, like a $100,000 speaker system to the vice president for the Rockets organization. And we didn't have a contract with the vendor. It was just a vendor I met, and I liked their system, and went to the vice president of the Rockets house, and he wanted a home theater. And I was like, okay, hell, I'll sell him this $100,000 speaker system. And I did, but that got taken away. That was cool. That was fun. So again, move that one, add that to the stage. What we're dealing with is insanity, folks. No questions about it. So if you're a federal or state custodian, you can now file as a class. Don't forget, we have the Bridge Project 24-hour flash sale coming up. Go get you some select items, 50% off. Stay tuned. I have a 6-minute promo coming up. Thanks for watching. Be sure to like, subscribe, share, hit that notification bell. Leave a comment below. Not for me. I don't care about any of that. But for the algorithm, so people that are your intellectual level will also get this video in their feed, and they can get turned on to this information. Thank you, everybody. You have a safe and happy week and weekend. I will see you when I see you. I may do something later today. I don't. Thank you for hanging around to watch this special promo on the new book by Ann LaFleur and Fearless Floyd, Specialty Trusts. We'll dive right in. There's the cover to the On Trust books. That's the first book that Ann wrote. This is the 3rd edition on revocable, irrevocable, foreign, charitable, remainder, express, college education, and land trusts. It has instructions, templates, examples, everything you need in this trust or in this book to run these 7 different trusts. Everything you need. Here's the table of contents. And please disregard the error bookmark, not defined, notices on the right hand of the screen. There is a lot of redundancy in this book simply because the simplicity of how it was adopted from the classes. So you're going to see, a trustee appointment letter in every one of the trusts when you just really need one, and just change the information. Here we go. This is a specialty trust cover. And here are all the trusts that are available in this book, How to Create and Operate Specialty Trust, full instructions, templates, and examples to create and operate a QTIP, a qualified terminal interest property trust, qualified personal residence trust, irrevocable life insurance trust, third-party special needs trust, community property trust, asset protection trust, discretionary trust, ministry trust, decedent trust, charitable trust, special needs trust, perpetual family trust, testamentary discretionary trust, grantor retained annuity trust, irrevocable farm trust, pets trust, AB trust, and marital trust, as well as the bonus DNA trust addendum. Here is the table of contents. And again, please disregard the error bookmark at not defined. And here we go with the DNA trust. Wanted to show you guys a little bit of this. That's the first 3 pages right there. This is the bonus. You can add this to any one of the trusts. Doesn't matter whether it's a revocable, irrevocable, foreign express, pets trust, same thing. If you'd like to get one of the books or a combination or a package, the ebooks are available for $249 each, and that's either the on trust or specialty trust books. If you'd like a soft cover, they are $259. I do have package deals available at thefearlessfloydshow.com/store on my website. If you'd like to do an a la carte package deal that I don't have available and you want to put something together, hit me up, thefearlessfloydshow@yahoo.com. I mainly hang out over on Telegram, so come hit me up over there. These 2 books are probably the only books you will ever need if you ever want to operate in trust, and everybody should at least research it and see if it's right for you and your family. Thank you for watching, everybody. I appreciate it. And I'll see you at the next show.